Hi, this is Curt and welcome to another edition of Fire Law Roundup.
Okay, let's go to Missouri for yet another one. And just if anyone is tired of hearing the 70% of cases, even though we don't cover them on sexual harassment, maybe we should stop harassing people. Okay, so we're in Missouri. I don't totally understand this, but there's a nurse who's hired by the Missouri Fire Department in April of 22, and she claims, right, this is just a lawsuit, so it's all allegedly, she claims that the on-duty and off-duty boorish behavior of a captain, and this is the one I mixed them up the other, this is a captain who was then promoted, person's promoted higher up.
Right.
He apparently is harassing her, tormenting her so badly that she first goes from full to part-time and then part-time and resigns. And so she is just, the lawsuit basically just alleges the elements of harassment, right? It was ongoing, severe, pervasive, et cetera. But I want to talk about that in a minute. Anyway, she said she was forced to resign. So that's most of it, just boorish behavior. We don't totally know what it all is.
And this was over a relatively short period of time. That's what struck me. That she was hired in June or May or June, and then really this took place in June and July. You can read. I didn't want to get into all the details of it, crap, but you can read it in the complaint. But June and July, and then all of a sudden now she's resorting to going to part-time, and then she ends up leaving because of that. So,
and the part I want viewers to understand, and you quote her elements, she quotes, her lawyer quotes the elements of sexual harassment and uses the term severe and pervasive, right? That normally, it used to be the case always, when somebody is suing for sexual harassment, they have to prove that it was severe and pervasive conduct. In New York State, and I think now other states, we have gone back to a standard from severe and pervasive, which is up here, to just a little bit more than annoying. It's not a big burden anymore. That's what New York did. It kind of bit Cuomo in the butt a little bit, who, thinks harass is two words. But nonetheless, Cuomo obviously gets accused of this. But sexual harassment, the burden of proof is coming down in states, starting with New York, I think was the first. I think
they are. I'm not sure.
You don't think other states? California, maybe? I don't know.
No, I thought New York was the first.
Oh, that's what I was thinking. I thought, yeah. I think New York is the first.
But I'm not sure if there's any other states that have. Has California? I'm not sure.
I don't know. Normally it'll be New York, California, or vice versa, and maybe a couple other, Delaware or something like that, some liberal states. But in any event, it's becoming easier to win. So be very careful, right? Look, we're becoming more sensitive, less tolerant, as we should, but it's becoming easier to win. So if we can't convince you, and when I do sexual harassment training, this is how I do it. If we can't convince you to shut your mouth and keep your hands to yourself and not harass anybody, then maybe we can convince you that it's not worth all your stuff, right? If you like your stuff, like your pension or anything, your house,
bank accounts,
your savings,
your car, your truck,
your wages, try not to harass anybody. Okay.